This case is number 20-60238, Warnock Engineering versus Canton Municipal Utilities. We'll hear first from Mr. McCraney.
Thank you, Your Honor. May it please the court. My client, Rudy Warnock, doing business through his firm, Warnock Engineering, LLC, was engaged for a period of time as the engineer for Canton Municipal Utilities, AKA CMU, which is a public utility commission within the city of Canton, Madison County, Mississippi. This relationship ended when a majority of the commission, 3 of the 5 members, voted to oust Warnock for what we contend are bogus reasons, and that occurred on December 22nd, 2016. At the time of the ouster, there was substantial engineering services which had been performed by Warnock, but not paid for by CMU. The 2 primary issues in this case and on appeal are, number 1, why was Warnock ousted? And number 2, regardless of the reason for the ouster, whether CMU is liable to Warnock under contractual principles for services rendered. As to the first issue, Warnock alleges in his complaint that the ouster was motivated by his refusal to participate in a kickback scheme solicited by CMU Commissioner Cleveland Anderson, and for alerting other public officials in Canton, including other CMU commissioners, about Anderson's corrupt behavior. As the record reflects, that alert was sent via text message dated December 17th, 2016. That's at record 5040 through 43. That was just a few days, I think 5 days before the special call board meeting occurred, during which meeting Warnock was ousted by a vote of 3 of the 5 members. It should be emphasized that 2 of the members voted against it. The 3 members voting for included Anderson, Cleotha Williams, and Lanny Slaughter. Anderson essentially admitted in the text message itself that he solicited a $200,000 kickback from Warnock, but he tried to spin it in the text message as if it was some sort of double cross where he was, quote, testing Warnock's loyalty and fidelity. That the solicitation occurred was also corroborated by the affidavit submitted in the record, and that's at 5102 by Canton Alderman Eric Gilkey, who corroborated that he too had been approached by Anderson regarding this, what we contend is an illegal kickback scheme. Warnock contends that the record supports a claim that CMU as an official governing body taking official government action through a majority of its members, represented by the 3 commissioners I just mentioned, is liable under Section 1983 and Monell for retaliating against Warnock in violation of the First Amendment and his First Amendment right to speak out against public corruption. The district court agreed or assumed that the proof supported all of the essential elements of a 1983 claim except for 2. The district court essentially ruled that Warnock had failed to present, quote unquote, direct evidence that Anderson's retaliatory animus was shared by the other 2 commissioners, Williams and Slaughter, who voted with him. We submit respectfully that the record evidence and the inference to be drawn reasonably in favor of Warnock, a finder of fact could conclude otherwise. The specific deposition testimony and evidence that supports that claim is on page 15 of our brief, where an excerpt from Anderson's testimony is set out, where I asked him in his deposition, is it true that you made a motion to terminate Mr. Warnock's contracts because he would not go along with the scheme to add $200,000 to a project for your benefit? And the answer he gave was, I don't recall. I followed up with a question, well, you would recall whether or not that's true or not, wouldn't you? The answer he gave, I don't recall. That's at record 5060. when he was asked in his deposition whether he had talked to the other two commissioners who voted with him about a plan to terminate Warnock just a few days later during a special call meeting, Anderson did not deny that such discussions occurred. He simply repeated a refrain, which I believe he said maybe 38 different times in his deposition, was "I don't recall." That's at record 5057.
Mr. McCraney,
Yes, Your Honor.
if let's assume that there's this "I don't recall" business is sufficient to raise a question of retaliation. Isn't the city also entitled to say that there were legitimate reasons that it's not a but-for cause of the termination of Warnock services?
Well, that was the alternative finding that the district court made, which was that, and I believe what you're alluding to is the concept that it would have made the same decision anyway, but for retaliatory animus.
Right.
And the response to that, Your Honor, is there's a question of fact about that. And
well, why is there a question of fact? Since your client admitted that he was attending various committee meetings that he had no obvious right to attend, he admitted that he was interfering with the employment of some people in the utilities division. He admitted that he was insubordinate. He admitted all that, didn't he?
No, I don't believe he did, Your Honor. Those were all.
He acknowledged that he had done these things. Well, he may not have characterized them as inappropriate, but he acknowledged in his deposition that he had done these things.
He acknowledged that there was disagreements within CMU about his role. However, whether those issues amounted to grounds to terminate him are fact issues. And the reason I say that is there's nothing in the minutes. You know, the minutes issue looms throughout this case. Nothing in the minutes suggests any issue or problem before this special call meeting concerning Warnock overstepping his bounds or being outside his lane or in any way acting improperly, whether there was any issue with his services rendered or the amounts of his invoices. Nothing appears in the minutes.
Well, how much had he been paid at this point in time by the city?
Up to the point of termination?
Yes, sir.
I don't know the exact dollar amount, but he had submitted.
$700,000, wasn't it?
It may have been, Your Honor, but he was also owed several million going forward.
Well, that's what you say. I'm quite shocked that a relatively small subdivision like Canton is paying out such huge amounts of money simply for engineering services. I presume he was not also a contractor. Is that correct?
He was. One of the contractors was a water and sewer improvement projects.
Had he put any shovels in the ground at the time of termination?
He had prepared a bid-ready design to essentially rehab the entire city and water and sewer, which was a flat fee contract.
Okay, that was flat fee. What was his ordinary hourly billing rate that the city would have been paying?
I don't recall. It's in the contracts, Your Honor. I think it was 150. And the rate varied depending on who was performing the services. And of course, to perform these services, he ramped up hiring a number of employees. But these questions are certainly reasonable questions, but they're for the jury to decide, Your Honor, as to what quantity and quality of his work was. That's exactly the issue that a jury should be deciding.
How come you're not saying anything about the alleged threats to rub out the mayor and the journalist at this point?
Well, that's certainly within the context of the unlawful behavior that and the corrupt behavior that Anderson was engaged in. But whether
why shouldn't we smell a rat here in regard to this alleged First Amendment activity of your client when what he's talking about is very serious potential crimes or attempts or solicitations, and he never went to prosecuting authorities.
Well, he did go to a law enforcement
That was a
colleague.
fellow who was working off the books for him as some kind of security advisor, who apparently testified or has an affidavit to the effect that he told Mr. Warnock numerous times that his confiding in him personally was not the same thing as going and making a formal investigative complaint.
Well, my response to that, Your Honor, would be that
That's not a
whether,
question of fact.
yes, Your Honor, that's a question
So
of
he
fact as to whether these were legitimate areas of public concern. Of course, the district court didn't make a ruling in that regard.
No, but he had seen a lot of this case by the time he did rule.
Can you
Well, Your Honor,
clarify? I'm sorry, go ahead and answer, Judge Jones.
thank you, Your Honor. No, I was just going to say the two issues that the district court ruled on was whether Anderson's retaliatory animus could be attributed to the other board members. We submit that's a fact issue because of the timing, as well as the deposition testimony that Mr. Williams and Mr. Slaughter gave, that they had no idea and no personal knowledge of why they were terminating. They had no issue or problem prior to that special call meeting. They had no personal knowledge of any issue with Mr. Warnock's performance. So it begs the question, and it's for the jury to decide, why did they vote to fire him? And they were the three members of the majority. And whether the reasons that were cited, none of the three witnesses could tell me where they came up with these reasons that were recited into the record during the special call meeting, which was like 8 or so very ambiguous statements about Warnock's prior behavior is what they relied on, but they couldn't give me any information about where it came from or what they based that information on. Again,
Well,
Cleveland.
Warnock admits all of this that happened. So several years after the fact, I mean, that's not so difficult to conceive that they had forgotten the exact source.
Well, I disagree that Warnock admitted that these things happened or that they were in any way untoward, Your Honor.
He admitted facts. He did not admit the adverse characterization.
Well, let me give you an example. You mentioned the involvement in or at least the allegations been made that he shouldn't have been involved in personnel matters. He was asked to sit on the personnel committee. Now, somebody later took issue with the fact that he had been asked to involve himself in personnel matters, but for them to then try to use that against him, that he's exerting undue power over CMU or what have you, again, that's simply a fact issue for the jury to decide, and whatever inference they want to draw from those facts and circumstances once they hear the testimony of the witnesses about that.
But you don't. But what you have is his self-serving testimony that he was invited to sit on the personnel committee. You don't have testimony from whoever actually placed that invitation.
No, I believe there's record testimony that I believe it's Cleotha Williams or Lanny Slaughter's deposition where they admitted that he was asked to sit on the personnel committee.
Counsel, you have a claim that you should have been granted leave to file a fourth amended complaint or a fifth amended complaint. I've lost count. What new or altered pleadings did you wish to make that you were deprived of that would, or are you not really urging that today?
Well, no, I mean, we contend, I mean, I think to answer that question, Judge, I need to give some background about how this issue arose, which was this lawsuit was filed by other counsel in 2017. There was a third amended complaint filed in prior to our involvement, March 12, 2018, that was then followed by a motion to dismiss and a motion for summary judgment filed by CMU The motion to dismiss did not specifically mention any issue about the minutes requirement. This lawsuit had been pending for over a year before that issue was first raised in their summary judgment motion as a grounds to deny any and all payment. In response to the summary judgment motion, we pointed out that while technically accurate, upon review of the matter having been first raised a year into the litigation, that the contracts at issue, the 3 contracts, weren't spread on the minutes. We pointed out to the district court in our response that should the court, and we hotly contested whether the minutes requirement deprived us of an express contractual remedy, but we said in the event that the court agrees with CMU that the minutes requirement renders the contracts, the written contracts, unenforceable, we would have an alternative claim for quantum merit under the Mississippi Good Faith Vendor Statute that we cited. The district court addressed that claim somewhat in its first summary judgment opinion. And because it was suggested in the opinion that the court didn't feel like we had either pled or had a right to plead that claim, we, within 30 days of that ruling, sought leave. Well, we said 2 things. We said, we believe that we've adequately pled this under federal, or that it had been adequately pled under federal pleading standards, particularly Rule 8 and 54C, that all that would be required to plead that claim is a short and plain statement of the factual basis for the claim. Paragraph 62 of the complaint, which is at ROA 3393, specifically says that at the time of the termination, Warnock was owed approximately $2 million. We argued to the district court that that was sufficient from a factual standpoint to assert that claim, and that there was no requirement that we cite the statute or quote or set out the words quantum merit in our complaint, which are legal theories.
What's your best case, Mr. Well, you know, if your client had been properly advised from the beginning, and by the beginning, I mean when he entered this contract with Mr. Weems, who according to the city's brief, committed suicide and is now deceased. Had he been properly advised by counsel, they would have made certain that the contract was spread upon the minutes. Also, since he was a public contractor, whoever represented him at the very outset as a competent lawyer, and maybe he was not, would have alternatively pled quantum merit. So what's your best case for saying that this very obvious problem in your client's case, which was not sought to be corrected until years into litigation, amounts to an abuse of discretion when the district court says, I've had enough of this? Because of course the court had gone through how many causes of action already that your client had pleaded and then withdrawn, 6 or 7 other different causes of action, and finally backed into a corner. You said, oh, well, it's really quantum merit.
Well, let me first address the point about, you said.
Why is it an abuse of discretion?
Well, I need to address the point you made about why the agreements weren't spread on the minutes. On that point, Your Honor, we submitted an affidavit from CMU's former attorney, Mike Espy, who testified that he personally instructed the city clerk to record those contracts in the minutes. And the record evidence is undisputed that neither Attorney Espy nor Warnock knew at the time that the city clerk had not done that and had instead, on her own volition, put them in a desk drawer. That issue did not rear its head until years into this litigation when it was first raised by CMU in its motion for summary judgment. We then sought reconsideration for the court to allow us to pursue this claim. And it's important to note that when the court issued its first ruling on summary judgment, it extended the discovery period by several months. It extended the trial date until October of 19. There was ample discovery. there was no discovery that needed to be done because, and the issue here is fair notice. The question is, did CMU have fair notice that an issue about quantum merit was in the case? Did it have fair notice that there was an issue about the reasonable value of the services were in the case? Well, the answer to that has to be, of course, because long before this came up, they had designated two witnesses, two professionals, an accountant and an engineer, who prepared 50-page expert reports contesting and nitpicking the value of Warnock services. How anybody can...
But the contract didn't exist at this point, and the value of the services is measured by reasonableness, not by the contract. And you're saying you're disputing them because they are taking a position you continue to rely on the contract for the value of the services. So more than arguably, your position at trial would have to change.
No, Your Honor, the contracts are certainly evidence of the reasonable value of the services rendered. Now, it's not necessarily dispositive, and the jury can come to a different conclusion as to what the reasonable value, but we cited cases in our brief where the courts have said that although the contract may fail for some legal reason, such as in this case, the minutes requirement, the value that the parties agreed upon can certainly be admitted as relevant evidence for the reasonable value on a quantum merit claim. The best case I can cite to you, Your Honor, as far as whether we were required to cite the good faith vendor statute is the Johnson case, where the U.S. Supreme Court said that you didn't have to plead to even cite 1983 to invoke a remedy once a plaintiff says the factual predicate for the claim, that is sufficient.
That may be sufficient when the plaintiff first files a claim, but you're talking about 3 years into litigation when you're asking for an amendment and a Fourth Amendment.
Well, again, the only reason we were asking for an amendment was because the court had dismissed our express contract claim, which then brought in or brings into focus our right to alternative relief, which you wouldn't need to plead.
Well, that was a foreseeable alternative situation. I know you say that Mr. Espy had told the clerk to do such and such, but when your client was first investigating his cause of action, that knowledge about being spread on the minutes is very plain in Mississippi law. I didn't believe it existed until I sat on another case within the past year or two, but that's practically a condition precedent to a public contractor making a lawsuit against a public body in Mississippi. The contracts are to be spread on the minutes. And again, had your client been appropriately represented, he should have looked into that immediately, it seems to me.
Well, all I can say is that he and the CMU attorney both believed that condition precedent had been satisfied. It was not until this issue came up in CMU's motion for summary judgment a year and a half into this litigation that issue ever surfaced. And I respectfully submit good cause existed then and there for us to seek leave to amend, for the court to allow us to amend that when, again, discovery was wide open. There was no trial date. All that would be required is to add the statute and the words quantum merit, which again, we submit is not even required under federal pleading standards. But out of an abundance of caution, we asked the district court for leave to allow us to do that. Now, had discovery been closed or trial date imminent, this may be a different case. But under these circumstances, and again, the court waited.
Okay, I'm not being rude. You've gotten a lot more than 20 minutes, so you've reserved time for rebuttal.
Thank you.
All right, Mr. Blackmon.
All right, please, the court. And I'm not going to go back into all of the history of how this case came about. I think that's been covered, but court's questions and with argument. Mr. Warnock filed this suit originally and alleged a number of grounds supporting his suit. a RICO action, a copyright action, and as well as, well, any number of other areas. But the copyright action, I think, has shed some light as to where the plaintiff thought he was going with this. He filed a lawsuit on behalf of himself and also on behalf of his company, Warnock Engineering LLC. The suit proceeded along through initially through various motions, and it was discovered during discovery that the copyright claim actually was just a ruse. Warnock Engineering LLC was never a party to the copyrighted material, so-called material. In fact, the copyright application was not filed until after the lawsuit was actually filed. The owner of the alleged copyrighted material was Warnock and Warnock and Associates, Engineering and Associates, which is another company owned by Mr. Warnock. That caused a dilemma for Mr. Warnock because during these proceedings, it suddenly dawned on one set of his lawyers, and I've forgotten which set it was, probably the new set, that the allegation concerning the copyright claim was dependent on having a proper plaintiff in the case, which it was not. In the middle of the argument on the motion for summary judgment, Mr. Warnock dissolved that corporation, Warnock Engineering and Associates. After it was dissolved, it then assigned its claim to Warnock Engineering LLC. Now, this was done without any leave of court. It was simply done in the response to the motion for summary judgment. I would call that yet indeed another unauthorized attempt to amend the pleadings. CMU is a public utility. You have to have their specific requirements with reference to contract. See, but CMU never had a contract with Warnock and Associates Engineering. But having realized that problem, eventually they decided to abandon that claim. Now, back to whether or not this was a claim that they originally pled on the basis of a quantum merit. No. No one, including the plaintiffs, ever considered this a quantum merit claim. The engineering is going on now by claiming that somehow our response in pleadings and the fact that we hired experts somehow put us on notice that somewhere in the background there, beyond the original contract claims, beyond the RICO claims, and beyond the copyright claims, was somewhere in there, buried in the weeds, a quantum merit claim, because we must have known since we hired experts. But this is what happened. And when we filed our original response, we reserved the right to amend our pleadings because we saw this plainly as a Rule 12 motion, dismissal or a summary judgment. We reserved our right to seek recoupment of the $1.2 million that CMU had paid Mr. Warnock for approximately 3 weeks of work. The engineers, expert engineers that we hired, was simply to tell us whether or not Mr. Warnock's, to support our future claim, that is, that Mr. Warnock had padded his building, which by the way, they admitted to doing. And we were going to use that as a possible means to get the money back on behalf of CMU. Given the amount of discovery that went on in this case, it is absolutely certain that if there was a quantum merit claim lurking somewhere out there in the shadows, we would have vigorously sought discovery on that particular issue. And our experts would have been asked to look at that as a possible a defense in the case. Now, with reference to whether or not there was some conspiracy to get rid of Mr. Warnock by the board. Now, I'm speaking about the board as a whole, not just Mr. Anderson. There's absolutely no proof of that. The court, I think, articulated it quite well in his ruling. Mr. Warnock was accused, well, he was dismissed for these reasons. he acted beyond the scope of his capacity as an engineer. He admitted that. He served, was in the middle of decisions on who to hire and who to get rid of. He admitted that. The board dismissed him because he was insubordinate in a manner in which he interacted with commissioners and aldermen. And to say the least, he was instructing or directing what people should be moved to different positions within the organization. Mr. Warnock interfered with the day-to-day operation of CMU. Mr.
Counsel,
Warnock,
what do you say to the argument by opposing counsel that these reasons, there's no, they seem to all be in lockstep and announced at this meeting on the phone, and that there wasn't a history or tracing back to where these came from that could have been from Mr. Anderson? And why doesn't that create a fact issue? And also, why don't the text and whether or not Williams and Slaughter actually did receive them and read them, why isn't that a fact issue that would also add to that point?
because Mr. Williams and Mr. Williams and Mr. Slaughter testified that they did not receive them. And
Right,
there
that's
was
a
no
fact. I
proof.
mean, you got them, you didn't, but you can check that, they were sent to them, but they say they didn't receive them.
Well, Mr. Warnock had a lot of opportunity during discovery to produce proof that they were actually sent. Those were screenshots that were offered into the record. There was no one else. There were other people allegedly on this stream of text messages. Not a single affidavit, no testimony at all from anybody else has said that they received those text messages or paid any attention that they got them. In fact, there's no evidence that anybody ever even responded to that text message. None whatsoever.
Okay, what about the reasons, you were going through the reasons of the termination, and I asked you, first of all, why does that not create a fact issue?
Well, because the board, the CMU board, just like other government entities, speaks through their minutes. It does not create a factual issue from any legislative body when you have to vote by a majority in order to enact policies, to go behind every person who participated in that deliberative process. You're going to get a lot of reasons why they arrived at point A or point B. The issue is, and the legal action is what was the decision that's recorded in the proper records, in this case, the minutes of the actions of the board.
Mr. Blackmon, was there any deposition taken of the other two board members who voted against terminating Warnock?
No, there were no deposition taken of those individuals. It was a board action. It was not an individual action.
Well, I understand that, but I mean, they could have said, that's it, that's very interesting. That's all.
Well, that was not done. But even as the court pointed out, even if he could cross that threshold of saying that the reason that I was dismissed was because of my protected constitutional First Amendment rights and protected rights. The fact is that through Mr. Warnock's own testimony, he corroborates the reasons that were articulated by the board for removing him. And one important fact that has not been mentioned here, Mr. Warnock, on the record, which is cited in the brief, testified that he participated in the theft of a computer from CMU. It was taken from the property of CMU to his office, where he then summoned his IT person to help unlock the computer for the purpose of looking at privileged personnel files. That encapsulates the kind of activity that Mr. Warnock was involved in. It also referenced back to the reasons cited by some of the reasons cited by the CMU board for removing him. Now that's testimony from Mr. Warnock himself. He also testified, and I think we listed a number of things that came out during discovery. For instance, reference to billing. Padding the billing came from one of his own employees. That testimony came from an employee who said Mr. Warnock instructed him to put billing hours in for work that he had not done. And it goes on in the record. I think the court was right. Our brief cites that there were certainly the reasons for dismissing Mr. Warnock were not pretextual. It overcame whatever inference that would be derived from the fact that he claimed that he had asserted some constitutional right. And even further, Jan, I'll just speak back something that was mentioned earlier in the earlier argument concerning his report that he made to law enforcement personnel. Now, that initially what he said was, I reported this to the investigating officer for the district attorney's office, which on his face sounds like he was really serious about getting this information out there, until we took the gentleman's deposition, wherein he stated, no, I am his personal security. I've been working for him for 8 years, and he was paying me off the record in cash. I've told him hundreds of times that no, I am not the official depository for this kind of information. You should go to the law enforcement. He told him where he should go, he said, to make that kind of report. It didn't happen. And one of the reasons it might not have happened is to go back and examine the real relationship between Mr. Anderson and Mr. Warnock. And we cite this in our brief. Mr. Anderson and Mr. Warnock were friends. Even after this alleged offer to commit crimes, Mr. Warnock was assisting Mr. Anderson in seeking to find other employment. Also, when Mr. Anderson did not show up at his Christmas party, he sent him a text, wanted to know why he hadn't attended. He also told him that you're a family, and like family, we always take care of family. This explains maybe why Mr. Warnock never really seriously sought to do anything if those acts had occurred. He only used it in this lawsuit to try to convey in his pleadings that he considered this conversation, if it was a conversation, and if it was a serious conversation, he's put into his pleadings, but his actions defy that, considering his relationship with Ms. Anderson.
Mr. Blackmon, I'm looking at the demand letter that some counsel for Warnock submitted to the utilities company on January 31 of 2017. So it's right after he was fired and was saying, here's how much money you owe me. And it lists many different items. You know, it says date billed, amount, date paid, amount paid, and then outstanding balance, which he totals up to over 6 million. Was there anything in the record as during discovery to underlie these invoices? In other words, were there timesheets? Were there drawings? Were there, indicia, objective indicia of how much time the engineering company had spent that supported its bills?
Yes, Your Honor, that was during discovery. But what we discovered is that much of the billing was unexplainable. Not just the witness who said that his record, he was not the only witness who said his records were padded at the request of Mr. Warnock. Other employees testified to that also. And I think telling here is that there were 0 deliverables for Mr. Warnock. And I do mean 0. Even after we got that letter, I think the record shows that there was a letter requesting that Mr. Warnock provide us with the specifics and support for your bills, and also the product itself. What we got, Your Honor, is that during the litigation was this copyright material, which turned out to be really not copyrighted material. It was materials that Mr. Warnock had gotten from CMU itself, and also materials that he'd gotten from his previous employer.
Well, what I'm getting at, I suppose, is that had the court allowed a fourth amended complaint to be filed asserting quantum merit, the city would have had to start discovery all over again to assess a reasonable amount of services. Is that right?
And I did have a note really to address that when he said that it would, how far we'd gotten in discovery. Absolutely. We would have had then to go back and then item by item and attempt to find whatever information we could out about each of those claims, especially since he was asking for over $6 million from a small utility that serves about 10,500 citizens here in Canton in a 5-mile radius outside of Canton. Obviously, we would be duty bound and obligated to have gone further with discovery if in fact it's turned out to be finally, as he's telling us now, a claim for quantum merit. And one point further, the court mentioned
On that question of quantum merit, when was the first time that you knew that this plaintiff was asserting something that was specifically identified as quantum merit?
in the third in their briefing on the third amended complaint.
So the complaint, though, as I understand it, was not
I'm
attached.
sorry, not the complaint, in this brief.
But the complaint was not attached, but there was a brief in support of the amendment. Is that right?
Yeah, well, the complaint was not attached to, under local rule 15, the court addressed that too. The complaint was not attached to the motion. We found out about the quantum merit claim in their response to our motion for summary judgment, the second motion for summary judgment.
Counsel, assuming arguendo, I'm sorry, go ahead, Judge Jones.
I just have a quick question. Technically, Mr. Blackmon, don't you agree that it's arguable whether the district court was correct in saying your client, Warnock, was not entitled to quantum merit? It looked to me as if he was a vendor to the city, or his company was.
Well, not under the statute, County. What the court the court mentioned the word standing, but the statute that Mr. Warnock is traveling on actually only applies to vendors who are not involved with creating the error or the problems with the contract itself. And obviously, it was Mr. Warnock's action that made the contracts illegal. That's according to Mississippi law. The statute that he's traveling under only applies where there's an innocent vendor. In this case, Mr. Warnock was anything but an innocent vendor. And I think, without the court having stated so, the standing issue had to do with whether or not he fit within that particular provision in the statute for innocent vendors.
Okay.
Okay, relatedly though, if assuming arguendo that we would construe the prior complaints, the live complaints, to include quantum merit because they state that the services are performed and you were entitled to reasonable pay for them. Just assume that arguendo. Then what happens? Because we do have some case law in our circuit that says that just stating the content of the claim without labels is adequate. So just assume for a minute that we would say it was, then what happens?
Well, I'm trying to see if I understand the court's question. What would happen if there was a quantum merit claim?
Yes, if there had been a quantum merit claim already in the third amended complaint, so there was a need to amend. And so, so then what happens?
If there had been, Yana, we would probably, this probably would not be an issue. It would have been addressed before. And therein lies the problem. But
that's what I'm saying. Assuming that we said today that there, and I'm not saying that we're going to, but if we were to say that there was a live quantum merit claim and the district court was wrong in saying that it needed to be amended to make it, and that it wasn't pleaded, then do we have to send it back? I guess that's basically my question. Is there any other way to resolve the case without sending it back if there is a live quantum merit claim?
If there is a live quantum merit claim, we'll start from square one again. If there is, we'd be back at square one. This case has been going on for more than 4 years. That would mean that we'll have to go back and then begin litigation with reference to that. And likely it would end up with a motion for summary judgment, and who knows where it would lead to begin with. But on the issue of whether on the Johnson case that counsel cited with reference to pleadings, I don't think under the rules and nor this court has completely abandoned the minimal notice requirement there is for pleadings. I think the language is, and in the Johnson case is that I think I'm reading and looking at it here. It says here petitioner stated simply, concisely, and directly events that allege entitle them to damages. That's what happened in the Johnson case. That was not. It's not what we have here in our case. Mr. Warnock is relying on one single stated amount in a contract case that he says exclusively elsewhere. It's a contract case. He puts in the prayer an amount and says, now you must know that I'm intending to pursue a quantum merit case. That's not what the rule says, and that's not what Johnson says.
All right, sir. I gave Mr. McCraney quite a bit of extra time. Without taking up too much of the court's time, is there anything else you'd like to highlight for us?
Yeah, now when that question is asked at trial on deposition, I always refrain from asking a question that I already have probably covered anyway.
Okay, thank you very much. Mr. McCraney, rebuttal.
Sorry, I had to unmute. Thank you, Your Honor. First point I'd like to address is Mr. Blackmon said that there's no evidence that any of the public officials in Canton who received or were copied on the text exchange took any action in response to it. The record suggests otherwise, and we pointed this out on page 14 of our brief, where we said that on December 22nd, 2016, which was the same day of the special call meeting at CMU, there was a meeting of the mayor and board of aldermen in Canton to call a special meeting to remove Cleveland Anderson as a commissioner and stop him, or at least attempt to stop him, from exerting control over the CMU board. That's at record 5029. The aldermen at that meeting, and this is also in the record, unanimously adopted a resolution stating that exigent circumstances existed to remove Anderson for cause. But then the mayor, for whatever reason, vetoed that resolution. So it's entirely a fact question as to whether action was taken in response to the exigent circumstances that arose by virtue of the text message that went from Mr. Warnock to Canton public officials, including Cleotha Williams and Lanny Slaughter, and simply a fact question whether they received it and met with or talked to Anderson about these alleged reasons for terminating Warnock that were recited. Mr. Blackmon mentioned some issue with a computer. That, of course, is not among the issues, nor mentioned anywhere in the minutes. So it's absolutely irrelevant. Mr. Blackmon mentioned that had the court allowed a quantum merit claim or a Fourth Amendment complaint, that discovery would have to be restarted to go through Warnock's invoices and deliverables and so forth. And that's just simply not true. The experts that they hired had already performed that work in their expert reports that were done and submitted and briefed on Daubert motions, which the court deferred ruling upon. All of that work was done. I don't know what possibly they could do more, and it's simply for the jury, again, to decide based on all of the evidence presented, what amount, if any, Warnock is entitled to recover for services rendered. Mr. Blackmon also mentioned that Warnock was somehow disqualified as a vendor under the good faith vendor statute because I think he said Warnock caused the illegality and therefore can't be considered innocent vendor. That is simply a fact issue based on the fact that CMU's own attorney was involved in and instructed the city clerk to record the contracts on the minutes.
No, I think he's talking about more than that.
Well, whatever he's talking about is simply a fact issue for the jury to decide about whether
It wasn't,
Mr. Warnock satisfies and certainly the district court made no finding or ruling
exactly.
as to that issue.
That's correct. And your time is up. And we appreciate arguments for both counsel. And we'll look at the case carefully, and the court stands in recess.
Thank you.
Thank you, Your Honor.